Now, so what type of verdict came in this past August?
Well, with the information that was provided, my son was, they said he was guilty.
Okay, now what type of prison sentence could he be looking at?
To be real honest, I know it could be, they have never, Mr. Mon has never really discussed that with me, and neither has his attorney, Laura Shaney Belt, has never discussed that with me.
Okay, all right. I thought I saw something that maybe possibly 4.5 years, but I may be wrong. Okay, now, could you tell us after the trial, did
So you did see a 4.5 year, but that was a letter that my son's attorney had given to him, and when I went to visit, I asked to make a copy.
Okay.
But up until, which was just last week, I didn't know.
Okay, so I guess today, you think your son could be sentenced to 4.5 years for this guilty conviction?
Well,
or do you even know?
No one has shared. No one has shared anything with me.
Okay, okay, Cynthia. We talked about how the trial ended, and after the trial, did you and your two friends meet with the court-appointed attorney Carl Mon to talk about the trial? And maybe you can tell us briefly what you and Carl talked about.
Yes, my two friends, our supporters, and my son and myself, we called Carl's office and made arrangements so we can go in and visit with him, because we were extremely disappointed in the results of the jury trial, as well as we knew that Carl was skilled and he could have won that case. So we called him and made an appointment.
Okay, how long did the meeting last?
Oh, probably right about 30 minutes.
Okay. At that point in time, did Carl mention to you any conversations he had with any of the jurors after the trial?
Yes, he did. He said there was a juror, and he said that one or two of them had made the statement that why didn't he fight for his client? And we were asking him, because we told him we did not believe that all 12 of those jurors went along with that bogus story. And he said they were asking him questions in the back. If this wasn't true, such a certain evidence that was introduced to the jury, then why didn't he interfere and do something about it?
Okay, now we're going to backtrack just a little bit, and do you recall during I guess the closing statements at the trial or the jury instructions, was there anything that Judge Flegel said that stood out that just seemed unreasonable?
Yeah, when he was talking to the jury, he gave them the direction that he said that he gave them the instructions that if 11 people said that he was innocent and just one person said that he was guilty, he would be guilty. And he also said to them that he would be the one, the court would be the one that would be making the final decision as to whether my son was guilty or not.
So just so I understand this correctly, to the best of your knowledge, if one juror found him guilty and the 11 other jurors found him innocent, then he would still be guilty?
Yes, they said the vote must be unanimous.
Okay. Now, do you recall if your two friends were there when Judge Flegel made these statements?
Yes, they were appalled.
Okay, they were appalled also. Do you recall if during your conversation with Carl at that meeting, did you talk about whether or not you thought Judge Flegel had acted unfairly? Did that come up in the conversation?
Definitely. That was one of the issues that we wanted to discuss with him. We talked with him and we let him know that everything that was overruled. We asked him about the. It bothered us that the prosecutor, at the end, that the judge allowed him to still introduce the picture of the tire marks, even though they had already been proved false,
Okay.
And other statements as well.
Okay, now after this meeting that you had with Carl, it looks like he introduced two different motions, or filed two different motions on September 7th. One was a motion to withdraw for the judge to appoint a new attorney for your son, and then the other motion was motion for judgment of acquittal, or in the alternative, a new trial. Now, I want you to talk about the first motion, which is the motion to withdraw. And you don't have to read it, but basically, is Carl talking about a conflict of interest between him and his client, and does he talk at all about the nature of the conflict of interest?
Basically, we let him know that we were very disappointed in the fact that he did not defend my son. He did not defend his client and my son, and that he allowed the court, the prosecutor, to basically run the courtroom.
Okay. Okay, so you think that Carl is withdrawing because he thinks you weren't happy with the representation?
We were very much offended at the lack of justice that he had toward his own client.
Okay. Now, the second motion, which was filed at the exact same time, motion for judgment of acquittal, or in the alternative, a new trial. And first of all, did you receive copies of those motions as soon as they were filed, do you recall? Or
this particular one, I do not recall receiving this one. It's a possibility.
Okay.
But the date that we visit him directly, right after a few days after the trial, we asked for a motion for acquittal, dismissal.
Okay. So he was basically following your could you tell did he say I'm willing to do it, or
he said no?
He said no.
Absolutely not. Nothing. Absolutely not. He wasn't going to do anything.
So at that meeting that you had, he told you, no, I'm not going to do it, but then he went ahead and did it.
Yes.
Okay. Now I want you to talk about some of the things that stand out in that motion that almost make it appear that Carl committed legal malpractice by not doing what he should have done, or making the arguments that he should have made during the trial.
Well, several things. He has a list here. Number 2, he mentions that no reasonable jury could have reached a verdict of guilt beyond a reasonable doubt based upon the evidence introduced. And he also mentions here that it is unreasonable to believe that in a well-populated parking lot of a public school in the middle of the day, the respondent forced the complaining witness from her car against her will, temporarily deprived her of the use and the benefit of that vehicle against her will, and engaged in physical contact with her against her will in a manner which caused bodily harm, and yet not one individual could be found who noticed anything alarming. It is further unreasonable to conclude that these alleged actions occurred while and then, thereafter, the complaining witness was seen laughing and joking with the respondent. Given the evidence introduced at trial, no reasonable jury could have reached a guilty verdict.
Now, does he also bring up some irregularities about Judge Flagel's jury instructions?
Yes, he does. He brings here that he brings out on number 5 that there are certain trial errors which negatively affected the jury's verdict and the evidence that the jury was allowed to consider. So they were limited. Those errors denied the respondent of his right to a fair trial before the jury of his peers as contemplated in the 6th Amendment to the United States Constitution, during which he would be presumed innocent until proven guilty beyond a reasonable doubt.
Okay. Now,